बच्चे आ रहे थे, मैंने देखा। स्टार्ट। Right. Good afternoon, students. Welcome back to Plutus IAS once again. Right. So yesterday we have discussed 2 years questions, that is 2023, 2023 and 2024. Sorry, 2022. Today we are going to discuss rest of the questions. So today we are going to cover 3 to 4 years questions again. And by one more session, apart from this session, by one more session, we will try to complete the polity part. Then we will go to the next part, that is economics. Right. So without wasting much time, we will go directly into the questions. Right. 2021, the question is, first question, under the Indian Constitution, concentration of wealth violates, right, which of the above options? Option A is the right to equality. Next is the directive principles of state policy. The C, the right to freedom. D, the concept of welfare. Right. So concept of welfare, the concentration of wealth, actually, under the Indian Constitution, concentration of wealth violates. So generally speaking, concentration of wealth violates the concept of welfare to some extent. But explicitly about the concentration of wealth and the need to control the concentration of wealth in the hands of the few people, that too the resources. In DPSP, it is clearly mentioned that the efforts, there should be efforts by the government that the resources are not concentrated in the hands of the few people, and similarly, the wealth should not be concentrated in the hands of the people. So these things are explicitly mentioned in the part of constitutional, the part 4 of the constitution. Part 4 of the constitution, that is directive principles of state policy. So correct option is option B. Option B, the directive principles of state policy. Right. Right. So this is the correct option. Even right to equality, somewhat right to equality is also violated to some extent, but in the right to equality is mentioned in the part 3. So part 3, right to equality did not expressly mention something related to wealth, concentration of wealth, etc. So in right to equality, other things are mentioned, like equality before law, equal protection of laws, etc. So the correct option becomes option B, that is the directive principles of state policy. So this part 4 of the constitution, it explicitly mentions that the government should make efforts that there is no concentration of wealth in the few hands. Right. Next question. Right. Question is, what is the position of the right to property in India right now? So the options are, it is a legal right available to citizens only. Option B, legal right available to any person. Fundamental right available to citizens only. Neither fundamental nor legal right. So these two options are directly, they are incorrect because by the 44th constitutional amendment, the right to property, earlier it was a fundamental right. In the original constitution, it was a fundamental right, but through the 44th constitutional act, it has been removed from the list of the fundamental right, and it has been made a legal right. However, it is not just available to citizens only, it is also available for any person. Right. So it is available to foreign persons also. So because of that reason only, foreigners are coming and they are establishing their organizations here and they are doing business. So that is possible because the right to property is available to all, not only citizens, it is available to everyone. Right. Next question, question number 3. what was the exact constitutional status of India on 26th January 1950 when Constitution came into force? The options are a democratic republic, option B, a sovereign democratic republic, option C, a sovereign secular democratic republic, and the fourth option, one more word is incorporated, socialist. So you know very well that this nature of the Indian state, right, or you can say nature of Indian state, that is mentioned in preamble of the Constitution. So the exact words that are mentioned in the original Constitution when it was adopted is a sovereign democratic republic. So you know very well two words, socialist and secular, which are mentioning about the state, they have added into the preamble, through the 42nd Constitutional Amendment Act. Right. So apart from that, one more word is also added, that is integrity. So these three words were added to the preamble of the Constitution through the 42nd Constitutional Amendment, and this is the only time when preamble is amended, right? So you should be in a position to know the basic facts about the preamble of the Constitution also. So here and now, now and then you will be getting questions based on the preamble also, right? Next question, question number 4. The constitutional government means which of the expressions? So options are a representative government of a nation with the federal structure. So a federal government need not be a constitutional government. It can be there in non-constitutional based governments also. Next is a government whose head enjoys nominal powers, right? So this is also not the exact meaning of the constitutional government. Next is government whose head enjoys real powers, right? So this is also an incorrect statement, because actually if we speak plainly, a government, or we can say the head of the government where there is no constitution, he will actually enjoys we can say real powers. So the correct explanation is a government limited by the terms of constitution. So that is actually the meaning of constitutional government. So in the Constitution, the limits on the government are mentioned, and it is also, in other words, we can also say it is being said about the Constitution that in the Constitution, rights to the people are guaranteed against the excessives, or we can say arbitrariness of the government or state. So in the Constitution, the fundamental rights of the rights of the people are protected, and they act as a limitation on the government. So option D gives the exact meaning of the constitutional government. So this is also a purely conceptual question. So you should be thorough with the conceptual aspects when it comes to polity. Right. Next question. Consider the following statements in respect of Bharat Ratna and Padma awards. Right. The statements are Bharat Ratna and Padma awards titles are under the Article 18(1) of the Constitution of India. Yes, this is a correct statement. Actually, Article 18, it speaks about right to equality. Right. So here actually in the original Article 18 of the Constitution, the titles like Zamindar, Iqtidar, etc. So titles that were conferred before the independence, they have been abolished, saying that in the previously, before the Constitution has been adopted, they have, these titles helped in exploiting the poor people, especially the common people. So it kind of created an unequal society. So once the Constitution came into force, all these kind of titles have been abolished. Like earlier titles like Zamindar, Iqtidar, etc. There were several titles, Patwari, etc. There are many titles. So they all have been abolished. However, there is a provision, there is a chance given through the Article 18 subclass 1 that so whoever are doing the public service, they can be conferred with the Padma awards, and several civilian awards and several we can say titles for military were also allowed. So under this article, the Padma awards and even Bharat Ratna, they are being conferred. So it is a correct statement. Next statement, Padma Awards, which were instituted in the year 1984, were suspended only once. So this statement is also a correct statement, because once, I think when the Janata government came into power, even the Padma Awards have also been suspended, saying that they are against the right to equality. They are violating the equality among the people. Again, when the Congress government has again came into power, it has reinstated the Padma Awards. Right. So second statement is also correct. Third statement is the number of Bharat Ratna awards is restricted to a maximum of 5 in a particular year. So this statement is also a correct statement. So not only conceptual, this question also has some facts, like you should know some facts also. Right. So correct answer is, correct option is option D. 1, 2, 3 statements 1, 2, 3 are correct. Next question. Right. So with reference to India, consider the following statements. Right. Statement 1 is judicial custody means an accused in the custody of the concerned magistrate, and such accused is locked up in a police station, not in jail. So this is an incorrect statement. Judicial custody is not meant by this thing. Second statement is during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Yes, this is a correct statement. Right. So which of the statements given is above are correct? So only statement 2 is correct. Right. So in this also, so you should be remembering the all the aspects related to judicial custody, interrogation, etc. Right. So you will study about this when you study the PD Acts, when you study the fundamental rights. There are preventive detention. Provisions are mentioned in the Constitution of India. So along with them, you will also study these things. So apart from that, I wanted to tell you one more thing, that so in these days, the rules and regulations related to bail also are in the news, because many high-profile people have been arrested by ED, including the Chief Minister of Delhi and the daughter of former Chief Minister of Telangana. So repeatedly they were applying for bail, but their bail has been being rejected multiple times by various courts, including the Supreme Court. So in this case, there is a chance that there can be a question on the principles and the provisions about the bails. So right. So the Congress also in its manifesto, it gave a promise that so they will make sure that bail, not jail, will be the motto of the judiciary or the police. So they want to provide bail as a justiciable thing. I mean, they want to make liberal the conditions associated with bail. So in this background, the issues related to bail will also become important. So try to have a understanding of the aspects related to bail also. So on the lines of these questions, there may be a question on the issues related to bail also. Right. Next question, question number 7. Right. Question is, with reference to India, consider the following statements. Right. First statement, when a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of her right. This is a incorrect, this is an incorrect statement. Right. Still, if the prisoner makes a sufficient case, it becomes the prerogative, complete discretion of the authorities to whether to grant a person the parole or not. Next is, state governments have their own prisoners release on parole rules. Yes, yesterday also we have seen a question like this, maintenance of jails, because this act is there that is enacted during the period of British time, that put the maintenance of jails and prisons in the states list. So maintenance of jails and prisons, it has mentioned, that power is mentioned in the states list among the 3 lists that are there in the 7th schedule. So this statement is correct. So correct option is option B, only statement 2 is correct. Right. Next question, question number 8. At national level, which ministry is the nodal agency to to ensure effective implementation of the scheduled tribes and other traditional forest dwellers. It is popularly known as the Forest Rights Act of 2069. So it is a straightforward question. It is the Ministry of Tribal Affairs which will oversee the implementation of the Forest Rights Act. So do not confuse with the Ministry of Environment, Forest and Climate Change, and also there is a chance that you may confuse it with the Panchayati Raj Act. So it is the Ministry of Tribal Affairs which oversees the Forest Rights Act. Right, next question. Question number 9. Right, a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which of the following articles of the Constitution of India? Right. So a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power. So mark these words: unguided, uncontrolled, and discretionary power in the matter of application of law. So it violates which of the following rights? So definitely it is Article 14. Article 14, that is right to equality. So whenever the subject matter of discrimination comes, discretionary power comes, it is going to violate the right to equality. Right. So these are other articles. I mean, they are not related with the discretion when it comes to interpretation of the law. So Article 14, which talks about the right to equality, so that particular law will be violated here. All right. Next question. Question number 10. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? So remember that there are many features about federal polity, but here the question is asking about the most suitable feature, or you can say essential feature. So option 1 is the independence of judiciary is safeguarded. Yes, actually this is part and parcel of the federal system, because the judiciary acts as a judge whenever there is a dispute arises between the states and the union. States on the one side and center or union on the one side. So there need to be an independent agency which acts as an arbitrator between the disputes, I mean on the disputes between the center and states. So to act in an independent and a transparent manner, that body should be autonomous and independent, and its independence has to be protected. So because of that reason, this feature becomes the one of the essential features of the federalism in the country. Right. We also see the other features, like the union legislature has elected representatives from constituent units. So it need not be a federal feature. So it is actually a feature of the democracy. Democracy, or to be specific, it is part of representative democracy. Representative democracy, it is not that is related with the federal structure. Option C, the union cabinet can have elected representatives from regional parties. So this is also not actually speaking about federalism, right? So it happens in the coalition governments. So it is part and parcel of coalition government whenever there is a hung parliament. Single party do not having the majority, right? So in that case, the cabinet can have ministers from the other parties also. Option D, the fundamental rights are enforceable by courts of law. Yes, this is an essential feature of our constitution, but it is not part and parcel of the federal principle. So it is another, it deals with the another aspect, that is rights of the people. So correct option is option A. Next question, question number 11. Which one of the following best defines the term state? So remember, this is also a purely conceptual question. You should know about the conceptual aspects of the polity and governance. Right, option A, a community of persons permanently occupying a definite territory independent of external control, and possessing an organized government. Yes, this seems the correct explanation of the state because it talks about a definite territory, and who are people who are independent of external control. So when people of a territory they are independent of external control, that is known as sovereign. Sovereign, I mean they are second to none, and possessing an organized government. So there is a government also which is organized. So these are the characteristic features of the state. We will also see the other options what are there. A politically organized people of a definite territory and possessing an authority to govern them, maintain law and order, protect their natural rights, and safeguard their means of sustenance. So here all the things are there. Apart from that, to govern themselves. So in terms, it is also it is also talking about democracy. But however, in this statement, the aspect of sovereignty that is missing. So in the following statements also, statement C and D, three aspects, that is having definite territory, next having sovereignty, and having a government or organized government to that matter. So these three aspects should be fulfilled to call a particular territory a state. So in the following options, given options, one of these three aspects will be missing. So because of that reason, they won't become the correct options. Right. Next question. Right. With reference to Indian judiciary, consider the following statements. Statement 1. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. So this is a correct statement, and it is actually mentioned in the Constitution of India. It is there in the Constitution of India itself, because it is we can say provision is provided, because whenever there is a huge accumulation of cases, the CJI has the option of calling a previous Supreme Court judge to once again join the judicial services and discharge on the cases, to act as a judge with the permission of the President. Second statement, a high court in India has the power to review its own judgment as the Supreme Court does. So this power is not given to High Court. Only the Supreme Court has this power of reviewing its own orders. So because of this reason also, it acts as a court of record. Court of record. So with this, it can review its own judgment. This power is given to only Supreme Court. The high courts and other lower courts, they do not have this power. So statement 1, only statement 1 is correct, and other statements are not correct. Right. Next question, question number 13. Right. With reference to India, consider the following statements. Right. The statements are: statement 1, there is only one citizenship and one domicile. Right. This statement is a correct statement because we are following single citizenship, and there is only one domicile, that is India. Right. Next statement, a citizen by birth can become the head of the state. A citizen by birth can become the head of the state. So this statement is only partially correct, not fully correct. Other people who have got the citizenship by naturalization also, by naturalization or some other means, if he becomes a citizen of India, that person is eligible to become the head of the state. So in USA, you will see this provision that only a person, a citizen by birth only can become the head of the state in USA. No other citizen can become. if a person attains citizenship through residence, through naturalization, by any other means, that person is not eligible to become the president of USA. So please try to remember this difference. Next statement, a foreigner once granted the citizenship cannot be deprived of it under any circumstances. So there is no provision like that. A foreigner can be granted citizenship, but there is no restriction that that citizenship can be taken away from him. There are many number of options that granted citizenship can be taken away from that person. So correct option is only statement 1 is correct, and correct option is option A. Right. So question number 14. Right. Which of the following factors constitutes the best safeguard of liberty in a liberal democracy? So question is, which of the following factors constitutes the best safeguard of liberty in a liberal democracy? Option A, committed judiciary. So this is completely opposite. Committed judiciary will not never ensure liberty. Right. So committed judiciary means what you understood? Judiciary falling in line with the government, or to be specific, falling in line with the executive. Right. So this is a committed judiciary, including committed bureaucracy, is a dangerous thing to a liberal state, or for that matter to a democratic state. It is a very dangerous state. So when Mrs. Gandhi was ruling, so we have to speak about the facts. So Mrs. Gandhi was ruling. There were some constitutional experts were there. They were criticized that the state or India is going towards the committed judiciary, because all the judgments, they were going in favor of the executive. Right. And Mrs. Gandhi herself, she called for a committed bureaucracy, that bureaucrats should fall in line with the government, and they have to at any cost support the measures taken by the government. So this is about committed bureaucracy. So these all are not at all good for a liberal and a democratic society or state. Option B, centralization of powers. So this is also, we can say, it goes against the principle of liberal state. Right. So in a liberal state, the powers have to be decentralized. More and more authority has to be conferred on the people. So with the 73rd and 74th Constitutional Amendment Acts, we have tried to do this one only, liberalization or decentralization of powers. So centralization of powers, it goes against the spirit of liberalism. Next is elected government. Right. So elected government is not exactly right. Not exactly. It also protects the liberal state or liberal democracy to a certain extent. But here the exact match is separation of powers. So separation of powers, it will ensure that there is a liberal democracy in the country, and not only it exists, but also it will be safeguarded. Right. So the here option D, separation of powers, is the foremost and most suitable safeguard in protecting the liberty in a liberal democracy. Right. So you will know, I think, the separation of powers means there will be executive. If it is the government, there will be executive, there will be judiciary, and there is a legislature. So there is division of powers, or we can say separation of powers. Division of powers takes place between the center and the states. So that is the division of powers. Here separation of powers is there, and to balance these powers there are checks and balances. There is a mechanism of checks and balances, so that no one, the other organ of the government, is not encroaching on the powers of the other organ of the government. So this separation of powers, it safeguards liberty in a liberal democracy. Right. So option D is the correct option. Right. Next, question number question 15. That question is, we adopted a parliamentary democracy based on the British model, but how does our model differs from that of that model. Right. Statement 1, as regards legislation, the British Parliament is supreme or sovereign, but in India the power of the Parliament to legislate is limited. Yes, that is a correct statement. So in Britain, what is the norm is, whatever the Parliament says, that is correct. So Parliament is supreme in Britain. So even the government, even the judiciary, they have to follow whatever that is said by the government, Parliament, because for judiciary there is no concept called judicial review in Britain. Judicial review is not there in Britain. So if the courts have the judicial review power, that can act as a check on the legislative power of the Parliament. That concept is not there. However, apart from that, there is no written constitution in Britain also, which could have controlled the powers of the Parliament. So the Parliament is everything in Britain. So however, in India, what is supreme? In India, not Parliament, not judiciary, not executive, but the Constitution is supreme. The Constitution is supreme. All the three organs of the government, whether it is executive, whether it is judiciary, or whether it is Parliament, they are deriving powers from the Constitution. So in India, Constitution is supreme, right? So when it comes to USA, it is being said that over time, I mean earlier while also, when Montesquieu conceptualized the division of powers, especially the USA, it is known for perfect balance when it comes to organs of the government. However, over time, not the executive, but the judiciary, it has acquired lot many powers through the concept of judicial review, etc. So in USA, practical purposes, all practical purposes, judiciary is supreme in USA, though there is a constitution, right? So, but in India, fortunately, the balance is still being maintained, and the constitution is supreme, right? Right. So select the correct answer using the code below and below. Correct option is option C. Both statement 1 and statement 2 are correct. Right. Next question number 16. Right. So question is, with reference to the union government, consider the following statements. So statements are, in Gopalaswamy Iyengar committee suggested that a minister and a secretary to be designated solely pursuing the subject of administrative reform and promoting it, right? So second statement is, in 1970 the Department of Personnel was constituted on the recommendation of the Administrative Reforms Commission 1966, and this was placed under the Prime Minister's charge. So second statement is a correct statement. So based on the Administrative Reforms Committee, the Department of Personnel was constituted. So second statement is a correct statement, and first statement is incorrect. N. Gopalaswamy Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reform and promoting it. So this statement is correct. I think this recommendation is also given by the ARC only, first Administrative Reforms Commission. So here statement statement 2 only becomes correct, right? So next statement, next question number 17. I think it is rather easy question. Right to privacy, R2P, is protected under which of the article of the Constitution of India? I think it is a very easy and straightforward question. Article 21. So the right to life and personal liberty. So by interpreting it widely, the Honorable Judiciary has discovered the right to privacy in the Article 21, that is right to life and personal liberty. And not only a right to privacy is recognized, but it is said that right to privacy is also a fundamental right. Fundamental right, that is particular right is interpreted from the Article 21. So this judgment has came that right to privacy is a fundamental right. It is inherently there in Article 21, that is right to life. So this judgment is given in the famous case of Aadhaar. Right. So in famous case on Aadhaar, so the Honorable Supreme Court has invented that right to privacy is a fundamental right. Right. So try to have an idea about the important judicial pronouncements in the past 1.5 years before the examination, because you can expect these type of questions. So at that time in 2021, this thing was in news. So Aadhaar case was going on that time. So judgment was came on Aadhaar. So based on that news only, this question here has been asked. Right. Next. So this question, actually the answer has been dropped out by UPSC. So we do not know the exact answer for this question. So I am also skipping this question. Right. So these are the 18 questions. These are the 18 questions that are asked in 2021. Still, it is a fair number of questions from the single subject, that is polity. So here also you can understand the importance of polity subject. And that too, if you see the questions, almost 50% of the questions are concept oriented only, and the rest of the questions are briefly based on facts and day-to-day developments, I mean based on the current events. So you should be thorough, not only with the current affairs part, you should be thorough with the conceptual part also. So when you study the NCERT books, especially the 11th NCERT books, 2 books are there, then you will get a grip on the conceptual aspects of the polity and governance. Right. So with this we will be concluding the 2021 questions. Now we will see the 2020 questions. Right, now we will see the 2020 questions. Right. 2020, first question is, a parliamentary system of government is one in which. So the question is about parliamentary system of government. What is meant by parliamentary system? Option A, all political parties in the parliament are represented in the government. So this is a directly invalid, and we can say blatantly erroneous statement. Only all the political parties in the parliament are represented in the government. This is directly incorrect statement. You can directly eliminate the statement. So all the political parties will never be, in almost all the cases, they will not be part of the government. Next is, the government is responsible to the parliament and can be removed by it. Yes. So this is the actual meaning of the parliamentary system of government. So through the parliamentary system of government, we will have a responsible government. So how it happens? So the government, or for that matter, the Council of Ministers, COM, headed by the Prime Minister at the center and headed by the Chief Minister at the state level, it is accountable to, or we can say, it is accountable to the lower house of the parliament, that is Lok Sabha. So here comes the principle of collective responsibility. So the Council of Ministers headed by the Prime Minister, it is collectively responsible to the Lok Sabha. So as long as they have the confidence of Lok Sabha, they will be in power. So once they lost the confidence, they will be removed. So the Lok Sabha can pass a no confidence motion. With that, the government has to resign from the power. So this is the correct explanation of parliamentary system. We will also see the other options. Right. Option C, the government is elected by the people and can be removed by them. So it is a kind of vague statement. Yes, the people are electing, the government is elected by the people, but only indirectly, because we have a representative system of government where people will elect their representatives and send them to the Parliament, and among the parliamentary members, they elect the government from there. So it is a indirect democracy, and that too, people do not have the right to remove a government from power right now. Because the people having the right to remove a government, it is the feature of a direct democracy. It is possible in direct democracy. So it is possible, direct democracy is possible only in countries where population size is very less. So it is in vogue in countries like Switzerland. So in a huge country like India, democracy, direct democracy is almost impossible, right? So this power is not there. So just government can be removed from the power only after 5 years. So when the next general election comes, they can choose to defeat that government, right? Only that option is there, right? So this is not completely correct statement. For that matter, it is a vague statement. Next is option D. The government is chosen by parliament but cannot be removed by it before completion of a fixed term. So this is a half correct, half incorrect statement. So the government is chosen by the parliament, to be specific, the lower house of the parliament. But it can also be removed by the lower house of the parliament by passing a no confidence motion. So it is this statement is half correct and half incorrect. So option B becomes the correct explanation for the question given. Next question, question number 2. Which part of the Constitution of India declares the ideal welfare state? So welfare measures, you can simply, it is a straightforward and direct question. So the welfare nature of the government, welfare nature of our society, of our country is mentioned in the directive principles of state policy, right? So it is a straightforward and a direct question. Directive principles of state policy. Next is fourth question. Sorry, question number 3. I think we have missed. Consider the following statements. Statement 1. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. So it is a directly incorrect statement. If you know about the doctrine of basic structure, you will straightforwardly know that this is an incorrect statement. Actually, basic structure is nowhere mentioned in the Constitution. It is the invention of the judiciary, right? First thing is, it is the invention of judiciary. And next thing, the judiciary itself did not define what is actually constitutes in the basic structure. So this concept of basic structure has come in the famous KB case, Keshwananda Bharti case of 1973. Right. So at that time, the judiciary did not define what is meant by basic structure or what constitutes the basic structure. But however, as the time passed by, it included several features of the Indian Constitution that are part and parcel of the basic structure. First, it included judicial review. Next, it included concepts like secularism. Next, it included like parliamentary system, etc. So as the time passed by, as the cases are coming to it, one by one, it started including one aspect after the other into the concept of basic structure. So now basic structure contains many things. Still it is open. Still the concept is not closed. So in the future, judiciary has the freedom to incorporate some other things also, recognize some other things also as the basic features or basic structure of the Constitution. So first statement is an incorrect statement. Next statement, the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Yes, this is a correct statement. So the judicial review power to the judiciary comes from the articles, Article 13 and also Article 32. So when it comes to the Supreme Court and when it comes to High Court, I think Article 225. Please relook into the article number when it comes to High Courts. But when it comes to the Supreme Court, the judicial review power comes from Article 13 and Article 32. So what is meant by judicial review? So whatever a law is made by the Parliament, whenever a law is made by the Parliament, the made by the parliament. The judiciary has the right to review the validity of that law, whether that law is in accordance with the principles mentioned in the constitution or not. If the court feels that there are, the principles that are mentioned in the constitution are violated in that particular law, the court can nullify and declare that law as void. Right. So that is actually the judicial power. So here option B, only statement 2 is correct. Right. Next question, question number 4. Right. So one common agreement between Gandhism and Marxism is, right, I think here some option is missing, but it's okay. So one common agreement between the Gandhism and Marxism is, so you should be knowing about the ideology of some of the prominent people. So options given here are the final goal of a stateless society. Right. Class struggle, it is only given by Marx, not by Mahatma Gandhiji. Abolition of private property, it is also the concept given by Karl Marx, not by Mahatma Gandhi. Mahatma Gandhi gave another concept, that is trusteeship. The concept of trusteeship is given by Mahatma Gandhi against to the abolition of private property, that is given by Karl Marx. So what is meant by trusteeship concept is, so here Gandhiji accepts the ownership of private ownership of property. A person can have property, but once his means are met, once his needs are met, he should use that property, whatever the property is there at his disposal, he should use that property for the welfare of other people. So welfare of other people, that is the trusteeship concept. And Gandhiji says that that person, the owner of that property, he should act as a trustee, only act as a trustee to that property, not as the actual owner of property. So indirectly he is saying that use this property at your disposal for the welfare of the others. So this is the concept of trusteeship. Right. So this is about the, I think, sorry, one more option is missing. I think there is a problem. So it's okay. However, we got the correct answer. So both of their goal is to have a stateless society at the end. Right. Next question, question number 5. Question is, in the context of India, which one of the following is the characteristic appropriate for bureaucracy? Option A, bureaucracy is an agency for widening the scope of parliamentary democracy. Right. So it is an incorrect statement. Bureaucracy is not there for widening the scope of parliamentary democracy. It is not that, we can say, purview. The bureaucracy is existing to implement. First thing is implement the laws or policies, whatever that is made by the government, that is its first duty. And second duty is to aid and advise the executive, or we can say political executive, in the formulation of policy. These are its two main specific, we can say, duties. Right. Next option, option B, an agency for strengthening the structure of federalism. So it can work to strengthen the structure of the federalism, but it is not its exact duty, primary duty. Right. Next option C, an agency for facilitating political stability and economic growth. So political stability we cannot exactly say, but we can say it is an agency for working for economic growth. So we can say partially this statement is correct. Next statement, option D, it is an agency for the implementation of public policy. Yes, this is the correct explanation of bureaucracy. So this is one duty, and another duty also it has. It is aiding the political executive or temporary executive. Actually, bureaucracy is also known as the permanent executive, and the political leaders who are elected, they will be known as the temporary executives or political executive, to aid the political executives in formulation of policy. So these are the basic duties of the bureaucracy. Right. Next question, question number 6. It is about the preamble. So the preamble to the Constitution of India is statement A, option A part of the Constitution but has no legal effect. Option B, not a part of the Constitution and has no legal effect either. Option C, a part of the Constitution and has the same legal effect as any other part. Next is a part of the Constitution but has no legal effect independently of their parts. So here option D becomes the correct explanation. So it is right. So option A is also on the face of it seems as the correct explanation, but it has no legal effect independently. So when we see with all the other parts that are there in the Constitution, it has some legal effect because if there is any confusion in interpretation of any part of the Constitution, then the judiciary will resort to the preamble to understand what is actually mentioned in those parts internally. So when we consider along with the parts of the Constitution, the preamble has its it has legal validity. So when the other parts are not concerned, it has no legal validity, and it is part and parcel of the Constitution. So earlier there are certain cases like Berubari case, etc. So during that time, the Honorable Supreme Court has said that the preamble is not part and parcel of the Constitution. But however, in the subsequent cases, it has reversed its own decision and said that preamble is part and parcel of the Constitution. But singly, only if we just see the preamble, it has no legal effect. It has no legal effect means a person cannot go to a court and ask the court that the items or provisions or whatever the items mentioned in the preamble, they should be enforced. So that power is, that aspect is not available to preamble when it is seen separately from its parts. So that is meant by no legal effect. So the correct explanation is option D is the correct explanation. Next, question number 7. Right. Question is, with reference to the provisions contained in the part 4 of the Constitution of India, which of the following statements are correct? So part 4 means it is DPSP, Directive Principles of State Policy. Right, now we will see these statements. Statement 1, they shall be enforceable by courts. So this is, if you know about the DPSP, on the face of it, this is a completely opposite statement about the DPSP. They are not enforceable in the courts of law. Just before I explained what is meant by enforceable by courts of law. So no person can go to the court and ask that, so these and these things are mentioned in the Constitution, that is in the DPSP, Directive Principles of State Policy, and please help us enforce them. So there is no backing like that for the items mentioned in the Directive Principles of State Policy. So the court cannot ask the government to implement the principles that are mentioned in the judiciary, or no person can go to court and ask that the items mentioned in the DPSP shall be enforced. Right. Next statement, they shall not be enforceable by any court. Yes, so that is the, another way of saying the non-justiciability or non-justiciability. So no courts, they shall not be enforceable by any court. Right. Third statement is, principles laid down in this part are to influence the making of laws by the state. Yes. So many constitutional experts, they have said that though the Directive Principles of State Policy, they do not have the justiciability, they work as a torchlights when the government is making or formulating policy. So they will influence the policy making in the country. So the correct statements are statement 2 and statement 3 are the correct statements. Statement 1 is incorrect. So relatively this question is also an easy question. Right. So next question number 8. Question number 8. Question is, consider the following statements. Statement 1, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of the legislature of that state. Yes, this statement is a correct statement, because so there is a provision in the Constitution itself that a person who is eligible to be elected as a minister, he can be appointed as a minister even though he is not a member in state assembly. But within the 6 months, he has to be elected to the state assembly if there is also a legislative council, to the legislative council also, state legislative council also. So within 6 months, if he or she is not elected, then he has to forego the ministry. So effectively for 6 months, he or she can be appointed as a minister. This statement is a correct one. Statement B or statement 2, according to the Representation of People's Act 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. So this is an incorrect statement. So once the sentence is served by that person, and after I think there is a cooling period of 6 years. So after completion of this 6 years, that person once again becomes eligible for contesting in the elections. So try to know about in detail about the Representation of People's Act also. So there you can expect these kind of questions from that Act, Representation of People's Act. Apart from that, the RPA, Representation of People's Act, it is mentioned in the mains syllabus also, directly mentioned in the mains syllabus. So apart from that, this is an election year, so general elections are taking place. So in this background also you may expect a question in the prelims and as well as in the mains, right? So the correct option is option A, only statement 1 is correct, right? The next question, question number 9. Consider the following statements. The statements are, the President of India can summon a session of the Parliament at such a place as he or she thinks fit. Yes, this is mentioned in the Constitution. The President of India can summon a session of the Parliament. Next statement, the Constitution of India provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct all the 3 sessions. So it is incorrect statement. So it is mandatory to conduct all the 3 sessions, but there should not be another provision is also there, right? So there is also another provision that the gap between the 2 sessions shall not be more than 6 months. However, 3 sessions have to be conducted: the monsoon session, the winter session, and the budget session. These are the 3 sessions of the Parliament, and they have to be conducted. They have to be conducted definitely, right? Next statement, third statement is, there is no minimum number of days that Parliament is required to be meet in a year. Yes, there is no explicit mention of, right, compulsorily for these many number of days the Parliament has to sit. So there is no mention like that. So this is a correct statement. However, so the concern is that when you will study in the decline of the Parliament that the number of days that is, for the Parliament is meeting. So it is year after the year, session after the session, it is decreasing. So it is decreasing. That is a grave concern. So earlier it used to meet for almost 120 to 130 days. in the beginning years. Now it has declined to less than 100. So it is around 82, only 82, 90 days only it is meeting. That too, there are many disruptions and parliament is not at all functioning properly. So this is a concern, and you will study about the decline of the parliament when you study the mains related aspects. So the correct option is option C, only statement 1 and 3 are correct. Right. So next question, question number 10. Consider the following statements. The statements are: statement 1, Aadhaar metadata cannot be stored for more than 3 months. So it is completely related to Aadhaar. So at that time, Aadhaar was in the news. So many questions on previous 2021 also we have seen a question related to right to property. So you can consider this in the current affairs topic also. So I am skipping this question. Next question, question number 11. Question is: Rajya Sabha has equal powers with Lok Sabha in which of the following? A, the matter creating new all India services. Here Rajya Sabha has higher power, more power than the Lok Sabha, because based on the resolution passed by Rajya Sabha only, a new all India services can be created. So here the Rajya Sabha has the upper hand. Next is amending the constitution. Yes, here the Rajya Sabha has equal power with the Lok Sabha. Other options also we will see. Option C, removal of the government. So here the Rajya Sabha has no role at all. So it is only the prerogative of the Lok Sabha to remove a government by passing a no confidence motion. Making cut motions. So here also cut motion is a kind of thing that is related to budget and money. So you know very well, when the things related to budget, money bills, etc., items that are mentioned in Article 110 or something that is something related to withdrawal of the money from consolidated fund of India, only Parliament has the upper hand. The Rajya Sabha has comparatively lesser powers. So here option B becomes the correct option. In Constitutional Amendment Acts, and also to a large extent in normal bills also. I mean ordinary bills, it has almost equal powers with the Lok Sabha, but whenever there is a joint sitting, because of the numeral superiority of the Lok Sabha, finally the Lok Sabha may have its say in terms of ordinary bills also whenever there is a joint sitting of occurs. But in the case of constitutional amendment bills, both have same powers, equal powers. So whenever a bill is accepted by one house and rejected by another house, there is no provision for a joint sitting. Right. Right. Next question. Question number 12. So question is about MP lads. So so it is also, I mean, whenever there are changes relating to MP lads, so here, I mean, now and then there will be changes to the MP lad scheme. So this is MP lads and MLA lad scheme is an important scheme. So whenever there will be changes to the guidelines of the MP lads and MLA lads, questions will be there. So I am also skipping for want of time. I am also skipping this question. Next question, question number 13. Which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? So untouchability is mentioned in Article 17, that is part and parcel of right to equality. Article 14 to 18, they deal with right to equality. So it is a straightforward question. So whenever there is an issue about the untouchability, it is violating right to equality. I mean, untouchability is abolished in India through the Article 17. Apart from that, we have also the Act of Civil Liberties Act. Civil Liberties Act of 1955. So to enable Article 17, enable this provision, we have brought in the Protection of Civil Rights Act, Civil Liberties, or we can say Protection of Civil Rights Acts. Protection of Civil Rights Act 1955 is there. So right, that is about this question, question number 13. Right, next question, question number 14. Right. So question is, in India, separation of judiciary from executive is enjoined by which of the below? Options are preamble of the Constitution, directive principles of state policy, 7th schedule, and another option is there. Unfortunately, that is missing. So here, directive principles of state policy, Article 51. I think Article 51. I am not exactly remembering the article. So it asks that judiciary has to be, executive has to be separated from the judiciary. I'm sorry, it is not Article 51. It is somewhere around 40, 45, 46, like that. I am not exactly remembering the article, but it is mentioned in the directive principles of state policy. One of the directive principles of state policy is that the executive shall be separated from judiciary, so that there is division of power, or sorry, not division of powers. The exact word is separation of powers will be there among the three organs of the government. So correct option is option B, directive principles of state policy. Right, next question. Along with the budget, the finance minister. So this is question related to budget and the provisions. You can consider this question in the economics also. However, we will discuss this question. Right. Question is, along with the budget, the finance minister also places other documents before the parliament, which include the macroeconomic framework statement. The aforesaid document is presented because of the because it is mandated by. So you know very well, FRBM Act is there, Fiscal Responsibility and Budget Management Act. So because of the provisions of the act, the finance minister, along with the budget document, he or she will also introduce this document, the macroeconomic framework statement. Right. So it is also a straightforward question. Next question. So question number 16 is a completely conceptual question. Right. So you should be thorough with the concept, then only you will be in a position to answer this question. Right. Question is, a constitutional government by a definition is a what government? Option A, government by legislature. So there is no concept called government by legislature. You can call it as the parliamentary form of government, because the parliament, the executive, hails from the legislature. So in that way we can understand this one, but however it is not a constitutional government. Next is option B, popular government. Popular government means a government elected by people. So it becomes the definition of the democracy. It becomes the definition of democracy, not the constitutional government. Option C, multi-party government. So we cannot exactly say multi-party government is a constitutional government. Hardly we can also call it as coalition government. But it is also part and parcel of a parliamentary form of government, or for that matter, it is part and parcel of the representative democracy only. It is part of this multi-party government is also a part and parcel of representative democracy. Option D, limited government. So this is the correct explanation of constitutional government. So what happens in the constitutional government is that the constitution demarcates the limit for the government. So you should not act over this border. So constitution in effect limits the power of the government. It creates a boundary for the government, and it says that it also guarantees the rights of the people. Gives guarantees the people against violation of their rights by the government. So that is actually the meaning of limited government, and the limited government is also known as a constitutional type of or constitutional government. Right. Next question, question number 17. Right. The question is, other than the fundamental rights, which of the following parts of the Constitution of India reflect or reflects the principles and the provisions of Universal Declaration of Human Rights of 1948. So you should be knowing about these things also. What is there in the human rights? What is there in the Human Rights Declaration 1948? So it is difficult that you might have an understanding of this one. However, you should be in a position to guess. Here, what best you can do is you can guess. You can apply the logic of intelligent or educational guess, and you can come to a conclusion. So preamble, it also talks about the rights, the justice, etc., social, economic, political. It also talks about unity and integrity. It also talks about brotherhood, etc. So you can make a guess that the human rights principles also are contained in the preamble of the Constitution. Directive principles of state policy. Here also many things are talked about, like ensuring the welfare of the people, protecting the weak and disabled women and children, ensuring the welfare of the children and women, providing, we can say, sufficient or sustainable wages, minimum wages for the workers, etc. Many things are discussed. The state also should ensure that there is, proper means of livelihood are available to the people of the state, etc. All these things are mentioned in DPSP. So you can guess, make a educational guess that yes, this part is also maybe containing the principles that are there in the Universal Declaration of Human Rights. Next, fundamental duties. Yes, fundamental duties are also, there are many things like having a scientific temper, respecting the fellow human beings, protecting and recognizing the dignity of women, etc., compassion towards other fellow beings and other living beings, etc. There are many things are mentioned in fundamental duties. So by the educational guess, you can come to the conclusion that so somehow the other, all the three that are mentioned here also here, they might be reflecting the principles or declarations that are made in this particular declaration. Right. So correct option is option D. Statements 1, 2, 3 all are correct. Right. Question number 18. Right. The question is, in India, legal services authorities provide free legal services to which of the following types of citizens? So it is, many details you should be knowing. So completely it is a, we can say facts based question. So to answer this question, you should be thorough with the concept of legal aid and also the guidelines, practical guidelines about the legal aid services. So this much we can infer from this question. It is a completely fact-based question. So not only the concept of legal aid and also the guidelines, particular guidelines also, you should be in a position to remember. Then only you can answer the question. Right. So this is about 2020 questions. Right. So here also fairly almost 18 questions are asked. So if we can take away one question that saying that it is from current affairs, like the Aadhaar case I omitted. So still 17 questions you have got from polity. So still we can say it is a fair number of questions only. So here also you will see mostly the questions are related to conceptual and analytical type only. Only few questions you will see the facts based questions. Right. Right. So next we will see the questions from 2019. So we have completed the questions of 2021, 2020, and now we will see the questions of 2019. All right. So question is, consider the following statements. Right. Statement 1, the 44th Amendment to the Constitution of India The 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. So this is an incorrect statement. There is no article like this through the 44th Constitutional Amendment Act. So 44th Constitutional Amendment Act, what in essence it does is, it has reversed all the, we can say, extreme measures or extreme amendments, extreme clauses that have been introduced through the 42nd Constitutional Amendment Act. Statement 2, the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of the independence of judiciary. So can you recollect what is this 99th Constitutional Amendment Act, or what was the Constitutional Amendment Act? Right? It is something related to appointment and administration of judges. NJAC, National Judicial Appointments Commission. Right? So this body was created to appoint the judges and also oversee the transfer of judges, etc., especially to the higher judiciary. So however, this NJAC has been struck down by the judiciary, saying that it violates the separation of powers and executive is interfering in the judicial affairs. So by saying that, the Honorable Supreme Court has struck down this law. Right. So still we are following the method of judges, the judges appointing judges, that is the exact word I am unable to recollect, collegium system. So still we are following the collegium system. The NJAC, 99th Constitutional Amendment Bill, was tried to remove the system, collegium system of appointments to the higher judiciary, but however that has been struck down by the Honorable Supreme Court. So correct option is option B, only 2 is correct. Next question. So it is a lengthy question. Question is about, consider the following statements. All right. So it is also largely it is about the impeachment of Supreme Court judges. So many factual things are mentioned. So one thing I can say from here is, just be thorough with the impeachment of the judges. Impeachment of judges. Some things you should remember, that no judge until now has been impeached through the this mechanism. So there were impeachment motions on certain judges, like 2 to 3 examples are there. However, before the completion of the impeachment proceedings, the judges themselves have resigned from their post. So because of that reason, no judge has been removed from their position through this impeachment process. So you should be thorough with the facts related to this impeachment process also. Right. So move to the next question. Right. So question is, the 9th schedule was introduced in the Constitution of India during the Prime Ministership of below. So I think about the First Amendment Act, I think when we were discussing yesterday, the first there was a question about the first Constitutional Amendment Act. So the question was out, which of the below amendments have been made to overcome the interpretations of the judiciary with respect to fundamental rights. So the Nehruvian government, it was trying to enact the land reforms. However, the judicial judgments were going against the government. So the First Amendment has been brought in, and through that the 9th schedule has been created, and there the laws related to land reforms have been kept in the 9th schedule, and this entire 9th schedule has been kept out of the purview of the judicial review. And the later developments also I have explained yesterday itself. Right. Correct option is option A, Jawaharlal Nehru. Next question. Fourth question. Question is, consider the following statements. First statement, the Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. Yes, this is a correct statement. There is a, if you see the general qualifications to be a member of the Parliament, So he or she should not be holding the office of profit. So like that you will see. But by this act, the Parliament Act, the Parliament Prevention of Disqualification Act of 1955, many posts have been exempted from the office of profit purview. That statement is a correct statement. Right. Next is the above mentioned act was amended 5 times. So it is a completely factual statement. You should be thorough with the factual statement. So it is correct. It is amended 5 times. So in future it may be amended further also. So you should be also thorough with that. Next is that our office of property is well defined in the Constitution of India. So this is an incorrect statement. The word office of property is mentioned, but it is nowhere defined in the Constitution. Right. So only through this act also not defined the office of profit, but it has mentioned some post that this post is not comes in the office of profit. This post not comes under the office of profits, etc., etc. Some posts are mentioned in the office of profit. So correct options are option 1 and 2 are correct. So sorry, statement 1 and 2 are correct. So option A is a correct option. Right. Question number 5. The question is under which schedule of the Constitution of India can the transfer of tribal land to private parties of mining be declared null and void? So you know very well when it comes to scheduled areas, governance of scheduled areas, 5th and 6th schedules come into question. So one of these schedules, the 5th schedule mentioned is here. So under that schedule, mining can be, the transfer of tribal land to private parties for mining, for that matter, for any purpose. 5th and 6th schedules do not allow transfer of land for a non-scheduled area person. That shall not take place. So reasons, yesterday also we have seen one question like this. So the reason is, the government believes that once the non-scheduled area people enter there, they will start exploiting the scheduled area people. That is the reason it is prevented. Right. Next question. It is about the particularly vulnerable tribal groups, PVTGs. Consider the following statements about the particularly vulnerable tribal groups in India. So you can have this question in society also. So there also we will have issues related to tribals, but however we will see this question. Question is, PVTGs reside in 18 states and 1 union territory. Yes, this is a correct statement. 1 union territory is Andaman and Nicobar, and there are other 17 states also they will live. Next statement, a stagnant or declining population is one of the criteria for determining PVTG status. Yes, this is a correct statement. There are 95 PVTGs officially notified in the country so far. This is an incorrect statement. I think around 120 to 125. So like that, PVTGs are there that are notified and declared. Irular and Konda Reddy tribes are included in the list of PVTGs. Yes, this is a correct statement. So Irular you will find in the areas of Tamil Nadu, Karnataka and Kerala. So the forest region covering these 3 states, in that area these Irula tribe will live. So Konda Reddys live in the coastal Andhra and Karnataka region, Odisha region, especially in the eastern, or you can say coastal Andhra, that too northern coastal Andhra states they will live. Vijayanagaram, Visakhapatnam, Srikakulam, etc. In these regions the Konda Reddys live. They are also PVTGs. So correct statement is 1, 2, 4. So it is also a completely facts based question. So I think and that year there might be a change in the list of the PVTGs. That's why this question has been asked. So you should be thorough with the changes, aspects related to current affairs also. Right. So the question is about, it is about the article 142. So we will see this question. Right. So question is, with reference to the Constitution of India, prohibitions or limitations of or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? So the correct option here is the Supreme Court of India is not constrained in the exercise of its powers by the laws made by the Parliament. So that is the correct explanation of Article 142. So under certain articles there are there in the Constitution, like Article 142. Another article is there, I am unable to recollect the article number, that pertains to the special leave petition. SLV, I think article number is 132 or 35, something like that. So these give exclusive powers to the Supreme Court of India. So whatever the judgments made based on these articles, Article 142 or that particular article, special leave petition, they are considered as equal to the laws made by the Parliament. So for this item mentioned, it is the option B is the correct explanation, right? So it is also a completely conceptual oriented question. So try to be clear with these kind of concepts, right? Next question, question number 8. So it is about the Legislative Assembly. We will see the question. With reference to the Legislative Assembly of a state in India, consider the following statements. The statements are: the governor makes a customary address to members of the House at the commencement of the first session of the year. Yes, this is a correct statement, and the same practice is followed at the center also. The President will make a customary address to the members of the House. Next statement: when state legislatures does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. So it is incorrect statement. The state legislative assemblies will also have their particular rules. They do not actually follow the rule that is followed by the Lok Sabha, right? So this statement is an incorrect statement. So here correct option is option A, only statement 1 is correct. Right, next question, question number 9. Right, so it is about the scheduled, once again scheduled areas and scheduled tribes only. So we will see the question. Right, consider the following statements. Statement 1 is: as per the recent amendment to Indian Forest Act of 1927. So I think that particular year there is an amendment to this act. So that's why this question has been asked. So as per the recent amendment to Indian Forest Act of 1927, forest dwellers have the right to fell the bamboos grown on the forest areas, right? So this is an incorrect statement, because the forest, bamboo that is grown in the forest regions, the people do not have the power to fell it, because it is not considered as the minor forest produce. Only bamboo produced in the open fields, bamboo cultivated on the open fields, that is considered as that is removed from the definition of the tree. So here the bamboo that is growing in the forest, it is included in the definition of the tree. So hence it is considered as tree. It cannot be felled by the people. However, during that year 2019, there is an amendment to Forest Act to encourage people to grow bamboo and diversify the economy based on bamboo. This amendment has been made, where the bamboo grown on the open lands, revenue lands or own lands, that is removed from the definition of the tree. So now the bamboo can be felled, that is grown on the open lands, and it can be used. Second statement is: as per the Scheduled Tribes or the other Traditional Forest Dwellers Act, that is known as Forest Rights Act 2006, bamboo is a minor forest produce. Yes, this particular act recognizes bamboo as a minor forest produce. Right. Next statement is the Scheduled Tribes and other Forest Rights Act. Again, it allows ownership of minor forest produce to forest dwellers. Yes, this is a correct statement. minor forest produce, the people, the traditional dwellers in the forest, they have the right to collect the minor forest produce like tamarind, honey, and other roots. So all these things they can collect from the forest. All these have been included in the minor forest produce, right? So try to be thorough with the definition of minor forest produce also, right? Correct statement, correct option is option B. Statement 2 and 3 are correct, right? Next statement, sorry, next question. Question number 10. Which article of the Constitution of India safeguards one's right to marry the person of his choice? So obviously it comes in the Article 21, that is right to life and personal liberty. So you might get confused that Article 19, it is right to freedom. You may think that I have the right to freedom, I can marry any other person, but that is not guaranteed under the Article 19, because you should also know that under immediately in the Article 19(1), you have given the 6 freedoms: right to speech, right to expression, right to assembly, etc., etc. I mean 6 freedoms are given, and right to marriage of your choice, that is not mentioned in Article 1. So there are reasonable restrictions in the form of Article 19(2) also. So remember that thing. That is enabled under Article 21, that is right to life and personal liberty, right? So Article 25 talks about right to freedom of religion. So there also it is not mentioned, no mention of marriage. I mean there is mention about there. I mean it applies to things related to marriage also, but this aspect that is especially mentioned, marrying the choice of his own, that is not there, right? So Article 19 and 30 are completely different. They are associated with some other things, right? So correct option is option B. Next question, consider the following statements. It is about the intellectual property rights. So you can consider this question in economics also. So for the purpose or for time being, we can skip this question. Next question is about the commissions. So it is related to polity only. We will see this question. Question number 12. Right. So which of the following suggested that the governor should be an eminent person from the outside, of the state, and should be a detached figure without intense political links, or should not have taken part in politics in the recent past? So clearly this is the recommendation of the Sarkaria Commission. So Sarkaria Commission gave valid and immensely useful recommendations for the improving of central-state relations, right? So at that time, the position of governor was a severe, challenge. The office of governor was making headlines, and the position has also been subjected to misuse. So in that context, the Sarkaria Commission has given valuable suggestions relating to center-state relations. So one of the major aspects focused by this commission is the office of governor. So this particular recommendation is given by Sarkaria Commission. So Rajmannar Commission is also, it has actually appointed by the Tamil Nadu government. Tamil Nadu state has appointed the commission, but it also made several valuable recommendations related to center-state relations. First, Administrative Reforms Commission, it focused on administrative aspects. National Commission to Review Working of the Constitution, it has given recommendations on many things, included one part is about center-state relations. One aspect it also covered is central-state relations. Right. This is a brief information about the commissions, various commissions. Next question is about the compensatory afforestation fund. So it is also something related to current affairs, and we can also consider this in environment. So for time being, I'm also ignoring this question. Right. We will see this question. It is related to polity only. Question number 14. So question is, in India, which of the following review the independent regulators in sectors like telecommunications, insurance, electricity, etc. Right? Which of the following review the independent regulators? So the options are ad hoc committees set up by the parliament. Yes, they can inquire into the independent regulations. They can inquire the independent regulations. Parliamentary department related standing committees. Yes, they can also inquire. Finance Commission, it cannot. Its functions are completely different. Financial Sector Legislative Reforms Commission, it is also not have the authority. Niti Ayoga, it is also completely, its purpose is completely different. So correct option is, so easily you can answer this question, though the question is lengthy. Correct option is option A, only statement 1 or 2 are correct. So this is actually about regulatory bodies. Regulatory bodies. Right. Next question, question number 15. So it is about the Maternity Benefit Acts. So you can cover this question in current affairs and government schemes. So for the time being, I am also skipping this question because of the paucity of time. All right. So social capital, it is also social capital. Yes, we will see this question, question number 16. In the context of any country, which of the following would be considered as part of its social capital? So all the proportion of literates in the population, so we cannot exactly consider this as social capital, though it is beneficial for the country. The stock of its buildings, other infrastructure and machines, it is straightforward. It is a wrong, not suitable statement. The size of the population in the working age group, no. It is not a social capital. We can say it is a working age population. It will constitute the, largely we can say, labor force. We can call it as the labor force. It is working age population will be 16 to 59 years. Next is the level of mutual trust and harmony in the society. Yes, this is known as the social capital. So correct option is option D. Right. So next question related to high courts and the Supreme Courts. We will see this question. Question number 17. With reference to the Constitution of India, consider the following statements. Statement 1 is, no high court shall have the jurisdiction to declare any central law to be constitutionally invalid. So this is an incorrect statement. There are many instances that many high courts, they have declared a law enacted by the center as invalid. So best example is NEET. Center has brought in several changes related to NEET exam. The Tamil Nadu High Court, it has criticized the laws and it has declared that law as null. So there is no bar on the high courts on passing judgments on the center's laws. Second statement, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. So this is incorrect statement. The Supreme Court of India has the power to review not only the ordinary laws but also the constitutional amendment laws. So it is part and parcel of the judicial review. It is part and parcel of the judicial review. Apart from that, the Supreme Court has brought in a new thing, that is, we have already discussed this, basic structure. So they have the constitutional amendment laws or acts, they also now has to pass the test of basic structure. So this statement is also incorrect. So neither 1 nor 2. Correct option is option D. Right. Next question is question number 18. In the context of polity, which one of the following would you accept as the most appropriate definition of liberty? So this is also a completely conceptual question. You should be thorough with the questions. Right. What is the most appropriate definition of liberty? Option A, protection against the tyranny of political rulers. Yes, somewhat it seems relevant. Option B, absence of restraint. Yes, this also seems relevant. Option C, opportunity to do whatever one likes. So it seems like, on the face of it, it seems like correct, but it is not incorrect. it is not the actual definition of liberty. So you can straight away eliminate this option. Next option, option D, opportunity to develop oneself fully. So this is also there, but it is not actually giving the meaning of liberty. Somewhat partially it is giving the meaning of liberty. So complete definition of liberty is, that is absence of restraint. That is the complete definition of liberty. So option D, it is partially giving the definition. Option A is also partially giving. Option C is completely incorrect. We cannot take that statement on the face of it. Right. So these are the questions from 2019. Right. 2019. So almost how many questions? Even we remove like 2 questions, still 15 to 16 questions are being asked from this question. So if you leave out the current events related based questions, so most of the questions are relating to we can say theory or concept only. Factual questions are only few. So try to have a clarity in the on the conceptual aspects also. Right. So now we will go into the questions of 2018. Right. So for this session, this year will be the last. So in the tomorrow session, we will complete the questions till 2014. Right. 2018 first question is, right to privacy is protected as an right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Indian Constitution of India correctly and appropriately imply the above statement? Right. Statement A, Article 14 and provisions under the 42nd Amendment to the Constitution. So 42nd Amendment is not at all related with the right to privacy. So you can straight away eliminate the statement. Article 17 and the directive principles of state policy. So here also Article 70 is not at all, not related with the privacy. It is related with untouchability. So you can, here also you can eliminate the statement. Right. So Article 44, if you take the option D, here also 44th constitutional amendment, it is not related with the privacy. The right to privacy concept emerged during the Aadhaar related issue, when Aadhaar related issue emerged. So it is a nuanced, new concept. So it is that too judiciary found solace in Article 21, that is right to personal, right to life and personal liberty, the freedoms granted and other freedoms granted in the part 3. So through that the concept of right to privacy has come. So correct option is option C, Article 21. Right. Next question, regarding the money bill, which of the following statements is not correct? Right. So regarding the money bill, which of the following statements is not correct? So first statement, a bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. Yes, this is a correct statement about money bill. All these issues are mentioned in Article 110. Option B, a money bill has provisions for the custody of the Consolidated Fund of India or the Contingency Fund of India. Yes, this is also a correct statement. Issues are completely pertaining to Consolidated Fund of India or Contingency Fund of India. Option C, a money bill is concerned with the appropriation of monies out of the Contingency Fund of India. So it is not Contingency Fund of India, it is Consolidated Fund of India. So the examiner has tried to trick you with the change of gamble of words. So this is not the correct statement about the money bill. So option D, a money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India. Yes, this is also related to this one only, Consolidated Fund of India only. So some things related to borrowing of money giving a guarantee also, they are associated with the Consolidated Fund of India. So this is also a correct statement, right? So what is the statement that is not correct in terms of money bill? That is option C, right? Next question, question number 3. With reference to the election of President of India, consider the following statements. Right, with reference to the election of the President of India, consider the following statements. The value of the vote of each MLA varies from state to state. Yes, this is a correct statement. So the value of the MLAs changes because the value of the, population also varies from state to, the size of the population varies from state to state. Next is the value of the vote of MPs of Lok Sabha is more than that of the value of the vote of MPs in Rajya Sabha. So this is incorrect statement. The votes of the values of MPs are, let's say, actually the MPs value of MPs of Lok Sabha is less than that of the MPs of Rajya Sabha, because in effect Rajya Sabha members are representing more and more numbers than the MPs. So it is an incorrect statement. So which of the statements given above are correct? Only statement 1 is correct, right? So the value of the MPs of Rajya Sabha is more than that of the value of vote of MP of Lok Sabha. Next question, consider the following statements. Right, consider the following statements. Statement 1, the Speaker of Legislative Assembly shall vacate his or her seat or office if he or she ceases to be a member of the assembly. Yes, this is a correct statement. Once they ceases to be a member of the assembly, they have to vacate their seat. Whenever the legislative assembly is dissolved, the speaker shall vacate his or her office immediately. This statement is an incorrect statement. So the speaker will continue to hold that position officially till the next speaker, that is pro tem speaker, is appointed, or next election is conducted, or next speaker is appointed. If Lok Sabha is not, legislative assembly is not dissolved, till the next speaker is appointed, he will hold his office, right? So practically he will not lose his seat immediately after dissolution of the state legislative assembly. So here only statement 1 is correct, statement 2 is incorrect. Right, next question, question number 5. It is about relationship between law and liberty. So completely here also it is a conceptual related question. So the question is, which one of the following reflects the most appropriate relationship between law and liberty? Right. Option A, if there are more laws, there is less liberty. Yes, on the face of it, it seems correct, but it is not correct always. This statement is not universally correct. Option B, if there are no laws, there is no liberty. Yes, we can go with this statement, because if there are no laws, the government, there will not be no controls on the power of the, government. So when government has, government has no restriction on its, we can say, powers, then it will impose restrictions on people. Then the people will lose their liberty. So this we can go through with the statement. Next is option C, if there is liberty, laws have to be made by the people. So yes, somewhat this statement is correct, but it is need not always laws have to be made by the people. The government or state itself can also make laws that that can enable liberty to the people. So this statement is also not universally correct. Option D, if laws are changed too often, liberty is in danger. Yes, this is also, we can also go with the this statement generally speaking. If a government is trying to change the laws frequently, we can understand that there is a problem. But however, this statement is also not universally correct. It is not correct always. So even a government is frequently changing the laws, still there may be, it may be working for the liberty of the people also. We cannot say. So it is also partially correct. So the most appropriate option is option B only. If there are no laws, there is no liberty, right? So this statement seems always correct. Next question, question number 6. The question is about governor. So we will see this question. Consider the following statements. Statement 1. No criminal proceedings shall be instituted against the governor of a state in any court during his term of office. Yes, this is a correct statement. No criminal case can be proceeded against the governor, or for that matter any constitutional authority like president, also president or governor, as long as they are in that position. Statement 1 is correct. Second statement, the emoluments and allowances of the governor of a state shall not be diminished during his term of office. Yes, this is also a correct statement. The office of governor has only a few protections. So among them, this is one protection. That the emoluments and the service conditions cannot be changed to his or her disadvantage while they are serving the office. Right. So one of the few safeguards that the position of the office of the governor has, this is one of those safeguards. So this is about the criminal laws. No criminal proceedings can be proceeded against them. What about the civil cases? Yes, civil cases can be proceeded against them. I mean, in civil matters, civil cases, we can proceed against them, but by serving a notice of 2 weeks. 2 weeks and 14 days. By serving a 14 days notice, we can proceed in the civil matters against the governor, or for that matter against the president also. Right. So correct option is option C. Both statement 1 and 2 are correct. Next question, question number 17. So it is once again it is conceptual question. Question is, which of the following are regarded as the main features of rule of law? Right. Limited powers. Yes, we can take this. Limitation of powers. Then if there is limitation on powers of the government, especially on the government, rule of law can be ensured. Equality before law. Yes, it is one of the core principles of rule of law. Equality before law is one of the core principles of rule of law. People's responsibility to the government. So this is not related to rule of law. People need not be responsible to the government. Right. Next is liberty and civil rights. Yes, these things shall be there, then rule of law will be ensured. So correct option is option C. Statements 1, 2 and 4 are correct. Next question, question number 18. So we will see the question, question number 8. Question is, if the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state. So Article 356, it talks about the President's rule, imposition of state emergency, that is popularly known as the President's rule. President's rule. Right. So options are, the assembly of the state is automatically dissolved. So it need not be dissolved, rather it will be kept in suspended in animation, something like it is called suspension in animation. So it will be suspension in animation mode, it will be put. It will not be dissolved right away. Option B, the powers of the legislature of that state shall be exercised by or under the authority of the parliament. Yes, this statement is a correct statement. Whenever a president's rule imposed in a state, the powers exercised by the state legislative assembly will be automatically transferred to the parliament. Option C, Article 19 is suspended in the state, so this will not take place straight away. Next is option D, the president can make laws relating to the state. So the president will not make the laws, the parliament will make the laws. So don't confuse. On the face of it, this statement looks correct because it is popularly called as president's rule. So you may think that the president will make the laws. No, the parliament will make the laws. So here the parliament, the powers of the legislative state legislature will be transferred to the parliament. That is the correct statement about the president's rule imposed under Article 356. Right, next question. It is also completely a polity question. The question is, with reference to the Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the powers to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of the such a designation. So it is a straightforward question. By the name you can find out the answer, that is Committee on Subordinate Legislation. Right. So it is a straightforward question. Next question. So it is related to Right to Information Act. So I mean there have been several amendments since 2019. So still we will see the question. Consider the following statements. As per the right to, it is not about right to information, it is right to education. Right. So as per the Right to Education Act, to be eligible for appointment as a teacher in a state, a person would be required to possess the minimum qualification laid down by the concerned State Council of Teacher Education. So no, the central government will decide the qualification. So a particular person will be completing the graduation in teacher education, like he should hold the degree of B.Ed, Bachelor of Education. I mean it is prescribed by the central government. It will not be decided by the State Council of Teacher Education. Next is, as per the RTE Act, for teaching primary classes, a candidate is required to pass a teacher eligibility test conducted in accordance with the National Council of Teacher Education guidelines. Yes, this is a correct statement. In India, more than 90% of the teacher education institutions are directly under the state governments. So this is also incorrect statement. So many facts are associated with this. So you should be thorough with the facts related to important acts like right to information, right to education, Manrega, so etc., Ayushman Bharat, etc. These related to these schemes. You should be thorough with all the facts. So not only they will be helpful in answering the prelims questions, but also you can quote that factual information or data in the mains examination to substantiate your points. So try to have data related to or facts related to important schemes, major schemes at least. So here correct statement is only statement 2 is correct. Very difficult question, by the way. Right. Next is, consider the following statements. The statements are, consider the following statements. The statements are, in the first Lok Sabha, first statement, in the first Lok Sabha, the single largest party in the opposition was the Swatantra Party. Right. I think the party, single largest party in opposition was, I guess, the Communist Party. If I am not wrong, kindly recheck. But it is not the Swatantra Party. Swatantra Party was there before independence. During the period between the periods between non-cooperation movement and civil disobedience movement. So at that time, the Swatantra Party played an important role. Next is, in Lok Sabha, a leader of opposition was recognized for the first time in 1969. Yes, this is a correct statement, because there is a criteria called the principal opposition party should get at least 10% seats in the total strength of a particular house. So till that time, no other party apart from Congress was in power, no other party was able to garner even 10% of the total seats. So because of that reason, no party was given officially the leader of opposition position. So presently also no party has in the previous Lok Sabha also there was no leader of opposition exactly in the previous 2 terms, because the principal opposition party, Congress party, it was unable, it could not gain at least 10% of the seats in the total number of the seats, right, in the Lok Sabha, right. Option 3, in the Lok Sabha, if a party does not have a minimum of 75 members, its leader cannot be recognized as a leader of the opposition. Right, this is incorrect statement. So it comes to around, I think, 45 or 46 seats, because the number of seats in Lok Sabha are 543. Sorry, the number of seats in Lok Sabha are, I think, 504. Total seats are 545. Effectively, we are having 543 seats. So the number comes around 54 or 53. So sorry, 54 or 55. So Congress party in previous 2 terms, it was getting seats, 40 plus seats it got. It unable to cross the number 50. So because of that reason, that it has not given the leader of opposition position. So it also led to many other problems, like various committees to appoint various appoint chairmen to various bodies. So that problem was there. However, a solution has been found out. So Lokpal, appointment of Lokpal was also big news, because a committee will appoint the Lokpal, in which the leader of opposition was also a member, but officially there was no member was there. Officially recognized leader of opposition, no person was there. So however, there were certain amendments were there. So the leader of the majority, largest opposition party, that leader of that party will be considered as the leader of opposition for when it comes to appointments to certain, to certain positions. In that way, a constitutional amendment act has been brought in. Then the appointment of Lokpal was made possible. So those are the later problems and developments. However, this statement is incorrect. So 10%, that the principal opposition party should get at least 10% seats of the total number of that seats allocated to that house. So here only option B option 2 is correct. Option B is the correct option. Next question, consider the following statements. Consider the following statements. Statement 1 is, the Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Yes, this is a correct statement. Parliament of India can place a particular legislation in the 9th schedule. So about 9th schedule we have already discussed. It is, for present, it is out of the purview of the judicial review. Second statement, the validity of a law placed in the 9th schedule cannot be examined by any court, and no judgment can be made on it. So this is an incorrect statement. So for some time that position was there. Judiciary was not touching the 9th schedule, but somehow somewhere in between, I think in the I am unable to recollect the exact case name. So in a particular case, the Supreme Court has said that we will also subject the 9th schedule to the judicial review. We have the power to also review the laws that are incorporated in the 9th schedule. So the Supreme Court has actually pronounced that. But however, it practically did not touch the laws that are mentioned in the 9th schedule. So in the future, there is a scope that the Supreme Court may go and touch the laws in the 9th schedule. So statement 2 is incorrect. So correct option is option A, only statement 1 is correct. Next question. Right. So it is a straightforward question. It is about the indexes. Rule of law index is released by which of the following organizations? So it is World Justice Report. So it is a straightforward question. You might expect questions like this also. So further you can consider this question in current affairs also. Right. So in this way there are practically we can consider 11 to 12 questions are asked this year from the polity. So in 2018. So you can say it is the one of those years where the polity questions have been reduced drastically. Right. So this is for today. In the next session, tomorrow's session, we will complete the remaining review of the remaining questions like 2017 to 2014. Then we will start the next subject, that is economics. Right. So this is it for today. Thank you for joining the session. See you tomorrow. Until then, have a good day. Right. See you next time.